but either didn't get any relief or only partial relief, that's the reason that they filed. But he's not stating that that's why they're damaged, because they didn't get it. What I hope I'm reading this right, and we'll see. There are greater legal minds who can, in a couple of minutes, look at all the different precedent there and say, yeah, okay, here's what this is all about. But that's what it seems to be, is the damage is the fact that they weren't able to make their case, and everybody should be able to make that case, and because there's a certain process which administration is supposed to follow. If you don't follow it and somebody can't make their argument, that's where the damage is.
Well, he writes in his 26 pages what's interesting, and again, you and I will need more time in order to break it down. But the defendants, which is the administration, seem to argue that no one has standing to challenge the program because where the government is providing a benefit, nobody is harmed by the existence of that benefit. And according to the defendants in administration, quote, sometimes the result is that there is executive or legislative action for which there isn't an appropriate plaintiff, end quote. The court must disagree. The Supreme Court has recognized that a plaintiff has standing to challenge a government benefit in many cases, and he cites some of those cases here, and including these, holding that one case holding that plaintiffs who did not qualify for the government benefits had standing. He's setting the precedent with these cases. Another case holding that the failure to receive benefits is enough to consider standing under Article 3. Because defendants' contention that no one has standing to challenge the program because it confers a benefit is incorrect. The court next turns to whether, the plaintiffs have standing. The two individuals, which were essentially represented with a conservative group filed on their behalf. Right. Plaintiffs allege that their concrete injury is deprivation of their procedural right under the APA to provide meaningful input on any proposal from the department to forgive student loan debt and their accompanying economic interest and debt.
Right, and just to get you right, plaintiffs allege that their concrete injury is a deprivation of their procedural right.
Right. Well, no, that's exactly what I'm. The process, the fact that they could not voice their concrete right in response to this, and that is why the process is set up. That's why it is first put in the Federal Register, and that there must be a public comment period. That public comment period gives the people that time to air their grievances officially through that process.
Right, and we said earlier, we understand the whole thing about, okay, taxpayers, if Congress comes up with something and passes a law that you as taxpayers can't say, wait a minute, I'm harmed because I have to pay more in taxes. The courts have already sort of thrown that out. But, and so, the other point is, okay, where were you damaged? Well, the focus seemed to be, were you damaged monetarily speaking? And if you weren't damaged monetarily, well, that's the only thing that matters. And what the judge is saying is, no, you're damaged as a citizen when the government doesn't follow the process that Congress has set up. They're supposed to have, that is part of the process, is the administrative hearing a public comment section. If you don't have the public comment, that's what the plaintiffs are alleging, that there is the concrete injury. Right. As for the plaintiffs' alleged deprivation of their procedural right, the APA requires agencies administrating their delegated authority to follow certain procedures. These procedures obligate agencies to subject their substantive rules to a notice and comment period unless an exception applies. A plaintiff is deprived of a procedural right to protect its concrete interest if an agency violates the APA's procedural requirements. Yep. And they list the precedent right there, Texas versus EEOC.
Right.
Yep. In 2019. And Summers versus Earth. And I don't know these cases, but what I'm saying is he's backing this up with precedent that comes before.
Right.
So, I'm assuming in his case, what he's saying is, I'm not making new law, but the damage is a procedural damage. Procedural damage.
Right.
And so, and just so people know, if you want to know, that's on page 11 and into 12 in the judge's decision. So, and that was the one thing, because after we had done the story, I sat there and I go, where's the actual damage? Where are they? And so during the top of the hours, when I said, okay, I got to find out where the damage and what is the damage and why do they have standing? And now I understand.
And that's where he spells it out here, literally. Thus, defendant's procedural error of not, that's again the administration's procedural error of not providing for a notice and comment period, which the court must assume as true for standing, is deprived. Plaintiffs of a non-illusory opportunity to pursue the benefit, he had that in quotes, of greater debt forgiveness and an opportunity to advocate for the expansion of the eligibility criteria of the program. The first requirement of Article 3 standing is thus met.
And the interesting point is, as I was just reading now, when you were stating that, is what they're saying is, the defendants, which would be the government. The defendant came back and said, wait a minute, but you can't, because the HEROES Act, we're basing our justification on the HEROES Act, and the HEROES Act exempts a notice and comment period. And he writes that the plaintiffs then disputed this and argued that because the HEROES Act does not authorize this program, and that's the whole point, because at that point the judge says, well, does this? That's actually pretty interesting. What they did was in the administrative thing, when the government came back and said, well, no, the HEROES Act makes it so you don't have to have a comment period, well, then the judge can make an analysis of whether the HEROES Act does justify the student loan transfer program.
Right.
Wow, that's really interesting.
Well, because you and I in our pre-show meeting, we were talking about a couple of things, and there's an interesting note to this. It kind of confirms it. What I was getting at out of, the layman's experience and eyes and skills, or lack thereof. Basically, the public comment period does not ensure that any of the grievances issued in those comments are going to be necessarily addressed. But we'll go back to Dumb and Dumber. So you're saying there's a chance, and this is what it comes down to. Plaintiffs argue that their injury is traceable to defendants' actions because plaintiffs lost the chance to obtain more debt forgiveness, which flows directly from defendants' promulgation of the program's eligibility requirements that failed to undergo a notice and comment period. And defendants, the administration, do not contest this argument. And the court agrees with the plaintiff. In other words, if there was a chance, it's not that the two defendants or two plaintiffs would have had their grievances addressed, and then the program would have changed as a result of their comments. It's that they were given zero chance because there was no public comment period, and even the administration doesn't contest that.
So what they're saying is, if they had the public comment period would have made this thing go on for a significant period of time.
It's
right.
I don't know. It's anywhere from 6 weeks to 3 months. I don't know if there is any given standard, but with a lot of items, it's at least 6 to 8 weeks.
So the question is, I would have to ask, if they held a public comment period for it, would this judge say that they would have had no standing at that point? So did the Biden administration?
Maybe.
Did the Biden, because that was the end, and now the judge says the end because he was able to compare, because their argument, the government's argument was because the HEROES Act said there didn't have to be a comment period, well, there doesn't need to be a comment period now, and then at that